Welcome back to the show, everyone. It's time now to answer your questions. We've gotten a lot of great questions all week long, so let's get straight to it. Actually, before we begin, we've been talking so much about class action lawsuits. It's a fascinating subject, but where did class action lawsuits even start?
Well, they've been around for a long time, and a lot of people debate the social utility of them. A lot of people are upset about them. Some people think that the lawyers get too much fees. A lot of people think that they're just clogging up our court systems. I want to let Val really answer the meat of it, but I can tell you that as a lawyer who has worked in the field of personal injury, that fits in the realm of my world, and I've worked on class actions myself. I've done some work with Mr. Exnicios here on them. My personal feeling is these class actions are responsible for bringing major companies, major drug manufacturers, major tobacco manufacturers to justice and holding them accountable. But I want to let Val answer the question more specifically.
Great question, Shauna. I mean, if you think about why class actions were first developed, right, it was to address a little bit of harm done to a large number of people. If one particular person only suffers, let's say, a $5 harm, let's say your bank, for example, charges you $5 a fee on your account, and it's not proper. They shouldn't be charging that $5 fee. It's very difficult for you to prosecute your claim against your bank because your loss is only $5. By the same token, if every account holder of the bank, if there's 1,000 people or 10,000 people who have all been charged this $5 fee, if you join all of those folks together and you have 1,000 folks who have a $5 loss, well, now you have a $5 million claim that's worthwhile pursuing. So what we didn't want to happen was a bank being able to just charge or a little bit of money improperly and get away with it without some kind of procedural vehicle available so that all of the folks who are harmed just a little bit could have their day in court and a redress of their grievance.
Well, we want to get to our questions, but this really takes us back to the story that we did earlier about Discover and other credit card companies, Capital One. We're seeing this so much.
It fits perfectly into that story. These major credit card companies, these mortgages that you've been reading about, these bad actions by huge corporations that nobody could afford to fight over these small fines.
On their own.
And it's only the fact that when you multiply it times tens of thousands, sometimes hundreds of thousands of victims, if the lawyers are able to aggregate all those claims and go after them and say, you're going to have to pay every one of these people back that little bit of money you took from them, class actions make that possible.
Okay, all right. Well, along those lines, let's get to our questions. Marie in Kenner, she writes in, she says, if I don't want to give up so much control of my case, is it wise for me to join a class action lawsuit? What are the disadvantages? How do I decide if this is something I should get involved with?
Marie, you really don't give up a lot of control of your case. It's really important to keep in mind that the only thing that's being determined via the class action is the fault of the defendant, whether or not they did or did not do something wrong that caused you harm, right? It's only the liability or the fault that's being determined there, and potentially what's called general causation. Did that fault do harm, cause some harm to everybody? The individual amount of harm that Marie suffered, or Shauna, or John, or anyone that's a member of the class, they are 1,000% in control of that because the individual amount of damages are not handled on a class action basis, but are handled individually.
In an individual basis. Okay,
yes.
This is very interesting because I'm thinking, what if what I'm seeking is totally different from what you're seeking?
Well, you get to address that individually within the class. But let me add this to what Val says. If you wanted to try and strike out on your own, get your own lawyer and go after that big company, well, do you really want to pay the costs of that all by yourself? Because remember, your lawyer generally gets a percentage of whatever he collects. But you have to reimburse that lawyer his expenses in addition to the fee, or her expenses in addition to the fee. Now, in a class action, one of the benefits that I'm not sure we mentioned it is, you take 10,000 claimants and you go after that big corporation, but you share the costs among 10,000 people. So your costs are 1/10,000th, generally speaking, for proving the causation. But if you do it by yourself and your lawyer has to go out and hire experts, go out and take depositions, go out and do stuff which can cost a lot of money, that's one reason why we said that $5 $5 fee you want to get reimbursed because they shouldn't have taken it, well, a lawyer's not going to take your case. But if you have a $100,000 case or a $200,000 case, if you try and go after a big corporation, it could cost $200,000 to go after them. That's why a class action, even on big cases, you want to share the cost with everybody.
Well, let's take the Discover case, for example. There's a report out that says that people paid almost $2.4 billion in fees that they were unaware of. The settlement that's been offered up is some $200 million. Some people are going to get credit, some people are going to get checks in the mail, but the average payout is just $56. What if I paid way more than $56? What other recourse do I have?
You can make that determination, Shauna. You can always opt out of the class, right?
Important.
If it's your determination is it's insufficient compensation, as long as you haven't waited too long to opt out, you can opt out of the class and participate on your own on an individual basis. Also remember, before, whether the lawyers involved, either for Discover or for the class, decide whether or not that's a sufficient amount of money, because off the bat it doesn't sound quite right.
It doesn't, right?
Over $2 billion worth of improper fees and only $200 million in settlement. Just because the lawyers agree that that's a sufficient sum is not the end of the day. There is a judge who has to determine that that settlement is fair to all the members of the class. And if that doesn't happen, there's no settlement.
Okay.
So.
And I'll just add briefly, the news media, people can jump to the conclusion that it was $2 billion in improper fees. Well, was it? I mean, what does the fine print in your contract say? Obviously, if it were a slam dunk, I think they'd be settling for a lot more money. If it's not a slam dunk, if you're going to have to roll the dice at trial, you might go to trial and lose. It might be the proverbial bird in the hand versus the 4 or 5 or 10 in the bush. So if the judge approves a settlement, maybe it is a bird in the hand that the judge says is fair and reasonable. That's one reason why it might be actually reasonable money, because it's not a slam dunk.
Okay, all right. Well, Jack has been waiting patiently, so let's get to his question. He says, what is a coupon settlement? Is that a real thing? Does it still exist?
Generally, no. The answer is...
Now, what is that?
A coupon settlement, class actions got a bad name because at one point in time, there was a group of lawyers who decided that what the victims were going to get was essentially a coupon from the defendant. If it was a manufacturer, let's take Procter & Gamble, Tide, or I don't know if they manufactured Tide, but whatever, Tide detergent, and what they were going to get was a coupon from Procter & Gamble for 50 cents off the next box of Tide that they purchased. The lawyers, on the other hand, were getting millions, if not tens of millions of dollars in fees. Fortunately, the courts have said, no, that's not fair, that's not reasonable, and in my opinion, you'll never have a coupon settlement again in this country. It's just not going to happen. Okay.
All right. John, did you want to add to that?
Well, actually, no, on coupon settlements, since it's kind of a thing of the past, I'd rather focus. We have very little time left. We wanted to just give a little bit of teaser. Next week, we're going to talk about BP litigation. Why don't you give us a brief overview of what people can expect to hear about the BP settlements,
right?
BP litigation settlements.
What we're going to do next week, John, is get into the meat, if you will, get into the heart of the BP settlement, talk about it, the litigation generally, but in particular, since everybody really has a keen interest in the settlement, BP settlement that's out there, it's a particular variation of a class action. It's called a settlement class, and we're going to talk about that, and we're going to talk about what's available to folks, because it is one of a kind. In 20-some-odd years of doing this type of litigation, I have never seen a settlement class like the BP settlement, and it really provides tremendous opportunity to folks here in Southeast Louisiana to receive compensation as a result of the BP disaster.
We are almost completely out of time, but when you say that it's one of a kind how?
It is so unusual, and so it provides so much benefit, potential benefit, to the folks who are victims here in Southeast Louisiana. It is truly an amazing settlement.
All right. Okay. Well, it looks like we are completely out of time. Val, thank you so much for being here. We look forward to our discussion. We're going to continue that next week when we'll have you on for our second part as we continue to cover class action lawsuits. So thanks so much.
Val, we're very grateful to you for being here with us. The topic is so challenging. It's so complicated. We decided that we really needed 2 shows to cover this. Next week it is going to be all about BP litigation, BP settlements. We look forward to having you with us. Thanks for being with us today.